are you?
Good afternoon, everyone. Before we start, I just wanted to thank everyone for your attendance today and your participation in what we hope is going to be a long and successful Pro Se Assistance Program in the Western District of New York. In preparing for today, I was looking at the Buffalo Law Journal, taking a break, and I read the New York State Bar Association's goals for 2014. And I'm going to quote it for you and then explain why we're here. I should probably introduce myself. I'm Chuck Kara, Pro Se Law Clerk for the Western District of New York in Buffalo. The governor and legislature must ensure that adequate funding is provided so the courts can fulfill their essential functions, including guaranteeing access to the justice system for the poor and the most vulnerable of our society. The Bar Association calls for a dedicated revenue stream to provide adequate funding for civil legal services for low-income individuals. Investing in civil legal services will save taxpayers dollars that otherwise would be spent on social services, housing, and other remedial programs. As most of you may know, Chief Judge Lippman of the New York State Court System has made it his mission in the state of New York to provide legal services to all indigent litigants who need it. In federal court, there is no dedicated funding stream for pro se litigants. There is none. It's the federal bar that provides those services on a pro bono basis to those litigants who the court from time to time assigns to represent them. It is our hope with this program that when a litigant first comes into court wanting to bring an action or to ask some questions if he or she can bring an action, they can finally meet with someone who can assist them. The pro se law clerks cannot assist them because we cannot provide legal advice. We can give them forms. We can give them some procedural and technical guidance, but we can't give them procedural or legal advice as to how to bring a lawsuit, where to bring a lawsuit, what type of lawsuit they may want to bring, or if they're in the wrong court or shouldn't be in any court. We hope by this program, with the assistance of UB, its students, its faculty, and volunteer lawyers program, we can finally bring, for the first time in the Western District of New York, some assistance to these litigants who need it. And today's program is all about what that program is going to mean for the litigants and the court in this district. And you see a lot of people up at this table, and there's also people out there who've been working on this program since last March when Judge Scretany met with the Dean of the UB Law School. After that, we met with Kim Connolly from the law school and Vice Dean Newton. And then we got Bob Olaudo and Gal Murphy involved from Volunteer Lawyers Project. And then we got Jody Galvin from the Federal Bar Association involved. And here we are today, finally able to introduce to all of you and the community the Western District of New York's Pro Se Assistance Program. I want to thank you for volunteering to participate in this program and providing whatever assistance you can to the litigants of this court and for your service to the court. Without any further ado, I want to introduce Chief Judge William Scretany of the Western District of New York. The judge is on trial. He's been picking a jury all week, so we're lucky to get him here. And as always, no further ado, Chief Judge Scretany.
Thank you, Mr. Chair. You know, it seems like nothing's sacred in federal court anymore. I mean, those were my prepared remarks. I mean, what is left for me to say? But welcome everybody to our Robert H. Jackson United States Courthouse here in the Western District of New York, and to our Pro Se Assistance Training Program. We're very, very excited about it. And, you know, I look around the room and, I mean, it's clear that we have some of the very best. And I know many of you have expressed your sincere interest in this program. And, I think all of that's going to come together, and this is a great first step forward with this training undertaking. You know, we started a while back, and frankly, we really did move with great speed to get this program up and running. And thanks go to a lot of people, and I'm probably going to repeat it at some point and especially mention everybody that's here again, because they really have put their shoulders to the grindstone and really worked very hard to get this program up and running. And it's a collaborative effort with UB's Law School and the Volunteer Lawyers Project. And it's really the latest of the initiatives of our Western District that's designed to serve litigants, primarily pro se litigants, and to promote, generally speaking, equal access to justice without regard to race or color or creed or status or ethnicity. All of those fall within the 4,543 words of the United States Constitution. If you want to go downstairs to the pavilion on your break and read all of them 7 times over on the outer wall of the pavilion, I mean, it's an amazing document. We work it and live it every single day. And what makes it so impressive, I think, is the commitment of our bar to undertakings and initiatives like the one that you are participating in today. We've been really coordinating this, in a sense, through a filter group, which is the State Federal Judicial Council and Conference, which meets regularly in New York City. And I've been going there several times over the course of every 6-month period of time. And we meet with some really outstanding jurists, a number of truly outstanding and extraordinary practicing lawyers, mostly from downstate, from all of the mega firms out there. And this particular group does a lot of coordinating of projects and initiatives that will best serve both the federal courts and the state courts. And we're in the spotlight, so to speak, because they're looking at us to see just what we accomplish through the efforts of this particular program, because this is the product of an initiative that, in a sense, started there. I mean, Chuck Kira has been amazing with what he does in his pro se capacity in our court. But we started talking about this maybe 18 months ago in New York City, and one of the first steps we took was to find out what information was out there in all of the districts within the Second Circuit. And we did get an overwhelming response. And this is the result of the analysis of that information, which we obtained, and we put it into an understandable format, which we've shared with our downstate members. But in effect, we're the ones that are taking the giant first step to get this undertaking in place with the information that we've assembled. And I say that just as the backdrop, because that puts us in sort of an incubator status, because we're working with the seeds of that information, and we hope to make it grow, and we hope that it will blossom from here. But it's an effort that's really seriously needed in our particular district here in the Western District. It would not come to fruition without the assistance of volunteer lawyers and the UB Law School and our own pro se program, and so many of you that have committed in many real respects to following up on Judge Lippman's initiative, which has been the product of probably 5 task force reports on the necessity for this kind of effort. And it's interrelated with the requirements that are new and extensive with respect to, among others, law students who have to fulfill, I think it's 50 pro bono credit hours before they can commence the practice of law. It's a give-back opportunity for our bar, but of course all of us have that pro bono requirement that in some instances has to be certified, which also is a part of the contract that you enter into when you are admitted to practice here in the Western District, because every one of you admitted to practice here has the requirement to participate in a pro bono effort from time to time and when called upon. So bottom line, it's an extremely important undertaking, and I thank you not only personally for that, but on behalf of all of my colleagues here in the Western District, all of our judges and all of our staff. We all recognize that this is very, very important, and what we're trying to do is take an initiative and put it together in a way that benefits students, in a way that benefits the bar, each of you, and we're trying to do it in a fashion that's more equitable and more knowledgeable. We don't want the same individuals, time and again, to be put in a position where they have to respond to inquiries from us to afford the kind of representation that we're asking you to undertake. I think what makes it fair is to spread the wealth, so to speak, and it is wealth, because it gives the opportunity for senior lawyers to share their mentoring abilities with junior lawyers to have the advantage of participating on a real basis in the litigating process of federal court, and to have some real courtroom experience. But we wanted to make sure that we refine our records so that the attorneys that we contact are viable attorneys. I mean, just to show you how maybe, I hate to say delinquent we've been, but Robert H. Jackson is still an active member on the rolls of the Western District of New York. And, in one respect, that's okay, and it's nice to have him there on our books, but he's not going to be all that helpful in this particular initiative, except inspirationally, and we hope not only he will continue to inspire, but all of you will be inspired and work hard to inspire others in this oh so worthwhile an effort. The mission of our program goes to the core of our legal system, and as Supreme Court Justice Lewis Powell once wrote, equal justice under the law is not merely a caption on the facade of the Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our legal system exists. It is fundamental that justice should be the same in substance and availability without regard to economic status. And I think if you think about that, you say, my gosh, you have to step back and, it makes you realize, and it should send chills up your spine just thinking about those words and the application of those words. And, we've just completed at 12:05 or whatever it was when I came down, just before I came down here, 3 solid days of jury selection in a somewhat mega case that's scheduled for roughly about 6 weeks of actual proof jury time. And, words like this we've repeated many times, and you could see how the citizens and cross-section citizens of our community appreciate really how important it is that they serve in a way that's fair and impartial, and that they don't distinguish on the basis of status or race or color, creed, gender, all those magical words that come into play when we're trying to do the job that our profession should be doing in our great community here in the United States. Now, the quote that I gave you is probably the first thing that the law student participants in our program will read when they pick up the course syllabus, and that's in term the pro se litigation practicum at the University of Buffalo Law School. That quote, I must confess, I shamelessly lifted Justice Powell's quote from Professor Bernadette Gargano's course materials, but since Bernadette was my law clerk way back when, she doesn't like to tell many people that, but I figure I have free lifetime access to her intellectual property. I think it's referred to as fair use, and I think it's called that, so I'm assuming that that applies here, Ms. Gargano. But, you know, that's really the bottom line mission statement of our program, and what we hope to accomplish through pro se assistance and this particular program with your assistance. Your experience, your expertise, that's instrumental and insurmountably necessary to the achieving of success of this undertaking. No doubt, it's going to monumentally benefit pro se clients on the one hand, eager UB students, I think, on the other hand. I don't know what your course response has been. I hope positive, good.
Very good.
You know, and somewhat selfishly the court, because, you know, I continue to tell everybody that the better the work product we get, I mean, Chuck, some of the stuff, Chuck Hara, that you and your department have to work through to find out if we have something that's frivolous, or whether we have claims that are meritorious, or whether we have to give additional opportunities for litigants to have another crack at pleading. I mean, it takes a lot of time and it takes a lot of effort. It's a lot harder work on the judiciary's part, and particularly our law clerks, in doing the, Jeff, you could probably make yourself available to comment on that, and you know, to work through that, so that the better work that you do and the litigants do, and you know, the better work that all of us are going to be able to do. Those of you participating, our law school partner, and of course, you know, the entire Western District bar. I hope it will benefit you. I'm confident in my own view that it will. That it's going to be a professionally rewarding experience. You know, mentoring is, when you think about it, and if you remember back to when you were law students, how much it meant to you to be properly mentored. Now to think that you're in a position to mentor others. And, you know, one of the most enjoyable parts of what I do is admitting new members to the federal bar, because first of all, they all look like they are still in grade school to me. And that's a sad commentary, I guess, for all the years that I've been around. But it's nice to see the younger members of our bar, I mean, their pedigrees and their accomplishments, and just, you know, really how terrific they are. But they do need that solid mentoring to become as good as they can possibly be. You know, you're going to get some more of the details this afternoon. You know, a lot of thought and energy and time in a concentrated period of time. I mean, Dean Matua was wonderful. You know, Jim Newton was terrific. He laid down the law. I know, Kim, when you introduced me from time to time, you made a point of saying, I got the order, I got the directive, this had to be done, this had to be up and running by this particular, I guess you call this the spring semester at the law school. And that was a tall order, but it got done. And of course, you know, Bernadette was, like always, very, very instrumental in getting the curriculum together. And Bridget O'Connell, you can't say enough about. And you know, we're we're excited. Bob Alardo, you know, he deserves kudos and sincere gratitude. Pro bono coordinator Gail Murphy, Bar Association, Volunteer Lawyers Projects. I mean, they've all worked together and selflessly and unselfishly to get this program started with the practicum in our clinic and this CLE. You know, our court staff has been terrific, and I think it's only going to get better. And, you know, it's a lot of work to put these initiatives in place, but well worth the effort. Betsy Sterling out in Rochester, I don't know if you've met her, but you know, she's obviously, you're going to get to know her a little bit better, and she's participating pretty extensively here too. You know, we have a director of this overall program effort, and I'm going to announce Robert Conklin's name today. He hasn't finally committed to that, but I figure if you all pressure him today, he might say yes. But you know, a person of his stature and his ability would mean a great deal to us. So we're working on him pretty hard. I do want to thank all of you for your time and your effort today. I want to thank you for willingly sharing your talents. Jody, for your efforts and support with the Temple Bar contingent that is now in place, and we really appreciate that. You know, we do have a noble profession, and our commitment to this pro bono service is really what I think sets our practicing bar apart in many respects from bars elsewhere. But you know, we can also inspire bars elsewhere to want to follow us and follow your example, and I think that's just around the corner. So again, I hope I haven't missed anybody that I probably should have thanked. There's so many, but to all of you, thank you for being here. Thank you for making the effort. We hope to expand this a little bit so that we don't run short. Our plan is, you know, to approach firms and managing partners and small firms and large firms and medium-sized firms, and you know, taking our attorney list and make that a productive list so that we can excel at what we offer litigants. We know that there might not be necessarily volumes and volumes of work to do immediately, but as we refine this, I think we're all going to see that when word gets out there, we're going to have a great response from those that otherwise would go through all kinds of angst and tribulation and unnecessary grief, so to speak, to try to get their claims heard in a meaningful way here in federal court. So thank you for having me here. Thank you to this great panel. Thank you to all of you. I hope you have a great CLE. I think the price is right. We try to do that whenever we can. And you know, I'm sure I'll get some feedback. So thank you very much.
Judge, on behalf of everyone here, I just want to thank you for taking the time to come down and speak with us today, and also the time you've taken in your role as Chief Judge to further the administration of justice and access to the courts.
Thank you, Chuck. By the way, did you take my keys so I can get back up?
No, but if I can get the use of the back elevator, I'll get them back.
I thought I had to put
This thing.
That's Okay, thank you.
I think the judge and I have mentioned everyone to thank, but there's one last person I want to personally thank, since I'm an absolute illiterate when it comes to anything computer-oriented, and that's Elisa Galloway from UB. Thank you for all your assistance throughout the many months with this program. And also, some of our students who will be participating in this program and also the family court program are here, and I want to welcome them to federal court in this program and hope to see you in many years to come. Our next speaker will be Kim Connolly. She's the Vice Dean for Legal Skills and the Director of Clinical Legal Education at UB. She's a tennis professor, so although we like to tell her what she can do, she really doesn't have to listen to us. So, again, Kim is going to go through what the program means, some issues about dealing with pro se litigants and the like. And again, I want to personally thank Kim for all their efforts in getting this program off the ground. Thank you.
And the wonderful Lisa Galloway, who is the backbone of making sure everything actually works, is going to make sure the PowerPoint gets up. Uh-huh.
Well, since it worked, I can now thank Joe Rubbish from our IT department. Thank you.
So it is a true delight to be here. We have been working on this for months, and it's been wonderful to get to know all these people much better than I knew some of them before, and some of them were brand new to me. So my charge here is to just spend a few minutes talking about the role of the law school and what's going to be happening with the way that the law school and the students support this. So to make that happen, I'm going to just say a few brief words about our clinical legal education program, talk a little about experiential learning and what clinics, the history of clinics and now Practica, our hybrid clinics, are doing, talk about what happens in Practicum, and then what we need from those of you who are going to be helping from the admitted attorney perspective. And then hopefully we'll have a few minutes to let you ask questions. So we have a clinical program. We've had a clinical program for many decades at, everybody calls it UB because it used to be UB, but a couple of years ago we officially changed the name, and I'll be in trouble if I'm on tape not to have said SUNY Buffalo Law School, but we still answer to our nickname, UB. So I joined the faculty in 2010 to direct the clinical program, and we worked together to come up with a mission statement for the program. Before I go on, how many of you took a clinic or experiential learning class when you were in law school? See, this is the new generation. So I think that you can kind of see what we try to do. We try to engage in practical legal thinking, ethical practice through client representation, policy development, effective problem solving in experiential settings, and let the student lawyers work with skilled faculty experiencing lawyers' unique and critical role as value contributors to the legal profession and larger society. So this is what our mission statement for our clinical program is about. And we really are, many people view us as the people who teach a lot of the skills. I view it in a broader way. And those of us in the national community that does experiential learning kind of don't talk about skills like really was the term of art in the 80s and the 90s. We're really talking about graduating profession-ready students. And so we go beyond the pure skills to a larger conceptual framework, which I think is going to be really important to what happens in this new practicum. Experiential learning in all sorts of areas has been deemed to be very powerful because you can get the underlying concept, but then by actually providing concrete experience and then opportunities to reflect, which is why we have a classroom component and other journaling and other requirements, and then working with abstract, then coming back, experimenting and doing a cycle of concrete experience with reflection and abstraction, readings, other assignments. And so that kind of is what we do and we've been doing for decades in the clinical legal education world. It's a very, very powerful learning tool. And there's a long history to clinics. One of the quotes that I love using is this quote from the late 1960s. Back when clinical legal education was really emerging and getting to be something that was quite common in many law schools around the country. And I have to tell you, talking to my friends who were there at the beginning, that many of the people who entered the academy were coming in from other places and showed up wearing their Birkenstocks and wanting to really change the world that way. But the concept that made it acceptable for other people within the academy was that applied legal education is placing the practitioners to be in the chaos of real life. There is nothing like something going on in your belly when it matters to somebody real that you do it right. Because you know what? I teach other kinds of classes. I teach classes where students write papers, and some of them write brilliant papers. Some of them kind of just know that it's going to be me and them seeing the paper, and they don't really care if they get a B or whatever, so they write an okay paper. But it matters when you're in the chaos of real life. It sharpens your skills. It takes all this stuff, teaches them the triumph over emotional stress and tensions, heightens appreciation of quality standards of practice, shows them what it's like to be people-oriented, enables them to help the machinery of justice function better by their presence as lawyers in training, and above all, exposes them to the complexities, the demands of justice on the level at which it operates. So this concept of what we're talking about here is not new. It is something that really emerged in the late 60s and became commonplace in the 70s, and actually required that some opportunity for this be offered by the 80s in the ABA accreditation standards. So this is why so many of you raised your hands. I'm sure I did experience learning in law school, because it kind of became a thing. Okay, this is like example 101 of a really bad PowerPoint. I'm sorry, you probably can't read it, but you can go off and find this. In the 1990s, there was a big important report issued by the ABA that we call the McCrate Report by the primary author. But it identified 10 skills and 4 values that we were trying to make sure that everybody who graduated from law school had. And it kind of reframed the whole, well, we get Socratic method and people walk out and they know the law and they don't think like a lawyer, into a whole new world. Identify problems, developing, implementing plans of actions to solve them. Identify legal issues, legal research skills, factual research skills, oral and written communication, counseling clients, negotiation skills, trial, appellate, administrative ADR, practice management, and ethics skills. All underlying this is values, competent lawyering, promoting justice and fairness, improving the professional development. Many of us acknowledge that this was part of a lot of what happened in law schools, but this was kind of groundbreaking because it put it out there, it changed the discourse among legal educators to acknowledge that we need to think about how to really best get this into the hands of the future members of the profession. So about a decade later, there were 2 reports that came out the same year, one of which was by the Carnegie Foundation called Educating Lawyers, that said that law schools were failing the profession. Law schools had to start demonstrating a true commitment to preparing their students. Even though the McCrate Report had been out there, even though there had been clinics, there wasn't something that was pervasive. And really called upon continuing dialogue with academics, practitioners, judges, licensing authorities to talk about how to do this. That's why we're kind of here today. It's why we're having these discussions. Primary goal should be to develop competence to resolve legal problems. So that was the Carnegie best practices of the Carnegie Educating Lawyers. At the same time, the group that at that point I was on the board of and later became president of the board was the Clinical Legal Education Association that published best practices that talked similarly. Law schools should demonstrate a commitment to preparing students both for bar examinations and for law practice, engage in continuing dialogue. So you can see that there were two groups of people who were appointed in very different ways, who brought together people from around the country who talked for years, who came out the same exact year and said pretty much the same thing. So here we are, we're in a world of, we have clinics, we have these things, but how do we make them even better? I arrived, as I said, in 2010 to a strong clinical program at Buffalo. I would not have taken the job had I not had enormous respect for what had been accomplished with some amazing people through things like the Women, Children, Social Justice Clinic, the Affordable Housing Clinic, the Environmental Policy Clinic, the Mediation Clinic. There was lots of exciting things going on. But I was also charged by my dean and by others when I was talking in the building of increasing the number of experiential learning opportunities and maybe connecting them even more directly to the classroom. So I came up with something that a lot of people are experimenting with called Practica. And so this is what we're doing here. It's not a clinic, which is in-house, so people are admitted to practice and really taking the first seat. In the clinics, typically the students are in the driver's seat of the motorcycle. They are in charge, they are first chairing, but there's a professor in a side-along car right there to whisper and to, if necessary, grab the wheel. You know, I always say to my students, you're in charge, but I'm your safety net and I'm not leaving your side. And by the way, I'm reading everything you're reading, so I'm making sure that you're really doing it right. So I mean, that's the beauty of being in a clinical thing. The practica kind of switches it. The practica has the students observing, assisting, being right there at the side, but not in charge, not driving, not admitted, not lawyering per se, but still in a very, very, very wonderful experience for getting a lot of what the Klepper and the Carnegie and Best Practices and McCrate have called for us to do. At our school, generally, we have all our practica, we now have 4, are 4 credit hours. There are weekly class meetings with substantive readings, and there's a required 120 hours of field work for the courses. The students, unlike in clinics, are not operating under a practice order. They are truly they're more like a law clerk in a firm. They're assisting, they're providing a lot of very interesting and wonderful work, but they really are in a side-along capacity. The thing that's different about this also is that there's a required short academic research paper. In addition to the classroom component when there's readings, here we have these students who are going to be coming in who are having these brilliant experiences with wonderful, amazing people right on the ground, and their ideas are probably coming up with, wow, maybe we should look at this differently. Maybe we need to talk about this, or this really interests me. So we give them an opportunity to choose a paper topic and spend just a short paper, a 5 to 7 page paper, that they get to explore something academically that they've observed, and then we share that. We share that in a way so that it can be shared with people in the community, both practitioners within the community and the larger academic world. We're sharing that on the law school website. Our first offering was a criminal law practicum, followed by healthy homes legal practicum. We now have a federal reentry practicum, and the newest one that is starting that we're here today for is the pro se practicum. And so we have a role in the law school's pro se practicum. I'm going to turn over to Bernadette in just a minute. Bernadette's like, whoops. Practicum at other schools. 15 of the 20 top ranked U.S. News and World Report schools in the clinical world have something like we have. So they have clinics as well as these things. They may call them something else, they may call them a hybrid or something. Our unique niche that pretty much nobody else is doing is adding this academic paper, and a lot of our other faculty are finding that to be very interesting and kind of bridging the